Yes, ma'am, you may start.
Okay, yes, Prajakta.
Yes, ma'am. Good evening to all of you. First of all, I request all the student teachers to take care that throughout the session, unless and until you are presenting or interacting with the speakers, please keep your microphones on mute and videos off so that we can conduct the session without any interruption. So now I would like to start the session with a deep thought. Peace cannot be kept by force. It can only be achieved by understanding. My name is Prajakta Bhor, second year student of B.Ed from MAEER's MIT St. Dnyaneshwar B.Ed College, Alandi, Pune. I welcome all of you to today's third day session of National Level Lecture Series on topic Combating Radicalism under the Project Aurora. Aurora, as we all know, stands for Alliance of Universities to Reinforce Teacher Training Curricula to Outcast Radicalism and Promote Equality in Asian Societies. After having insights into the topic radicalization, its concept and definition from Dr. Vijay Khare, and on topic limits of radicalization, human rights from Dr. Samadhan Nikum, we today have Advocate Prajjwal Sanjay Bhalgat, legal advisor Pune, to enlighten us on the topic UN Alternative Measures Legal Framework. First, the Tokyo Rules. Second, the Nelson Mandela Rules. I, on behalf of MIT St. Dnyaneshwar B.Ed College, extend a very warm welcome to you, sir. I also welcome additional DIGs and police officers from various places who have joined this lecture series. I also welcome our principal of MIT St. Dnyaneshwar B.Ed College and convener of the lecture series, Dr. Surendra Hedkar, sir. Thank you so much, sir, for introducing this important topic as a part of our B.Ed course 212 and also for giving us a platform where people of different sections have come together. I also welcome our professor and coordinator of lecture series, Professor Sanjay Shinde, sir. I also welcome participants from the Department of Defense and Strategic Studies, Savitribai Phule Pune University, and from Department of Dr. Baba Saheb Ambedkar Studies, Savitribai Phule Pune University. I warmly welcome all the student teachers of MIT's MIT Sant Dnyaneshwar B.Ed College. Now, one has rightly said, every breath we take, every step we make can be filled with peace, joy, and serenity. With this beautiful thought, I request you all to join in the MIT World Peace Prayer.
नमो जियाद्या वेद प्रतिपाद्या जय जय स्वसंवेद्या आत्मरूपा देवातूति गणेषु सकलार्थमतिप्रकाशु म्हणे निवृत्तिदासु अवधारि बोधि गुरुर्ब्रह्मा गुरुर्विष्णु गुरुर्देवो महेश्वरः गुरुसाक्षात् परब्रह्मा तस्मै श्री गुरवे नमः ॐ पूर्णमदः पूर्णमिदं पूर्णात् पूर्णमुदच्यते पूर्णस्य पूर्णमादाय पूर्णमेवावशिष्यते ॐ शान्ति शान्ति शान्तिः
also being the part of Savitribai Phule Pune University, let's join in for the Savitribai Phule Pune University anthem. Thank you, everyone. Now, I would like to request our Professor Darshana Pawar ma'am to kindly introduce today's resource person, Advocate Prajjwal Sanjay Bhalgat sir. Over to you, ma'am.
Yes, thank you, Prajakta.
Okay, so good evening all, and a heartily welcome to the third day of the national level lecture series on the combating radicalism. On behalf of MITE's MIT Sant Dnyaneshwar B.Ed College, Alandi Devachi, my assistant professor Darshana Pawar would like to give heartily welcome to today's honorable guest speaker, Advocate Prajjwal Sanjay Bhalgat. So, Advocate Prajjwal Bhalgat is a legal advisor in Pune. Their education qualification is fifth year of Bachelor of Arts, Bachelor of Legislative Law, that is a BA LLB. Sir has completed Common Proficiency Test conducted by the Institute of Chartered Accounts of India. He has completed integrated course on Information Technology and Soft Skills conducted by the Institute of Chartered Accounts of India and also completed orientation program. Sir has great strength and skill in various areas in which he is working. Strong and clear understanding of corporate and civil law, quick in reading and understanding judgment and case law, familiar with various research tools such as the Manupatra and also government tool of digitalization of judiciary. Advocate Prajwal's profile is too long. I'm reading this only due to time bind. We have received a very eminent speaker for today's lecture series on the third day for the topic of an alternative measures legal framework, the Tokyo rules and the Nelson Mandela rules. Sir, once again heartily welcome to you. Thank you very much. Now I request to Advocate Prajwal sir to grace the session. Thank you, sir. Over to you.
Thank you, Darshana ma'am, for such a wonderful welcome. Thank you, Prajakta. Myself, Prajwal Sanjay Bhalgat. I am from Chinchwad. I know Tupsanda sir personally. He is a very good friend of my dad. My dad is also a lawyer. He is working in the law profession for past 30 years. So time is a main concern here. So I would like to get started with the topic, because I was reminded by the college authority that sir, you have to complete the lecture in 1 hour, and the topic is very vast. That is next to impossible to complete the topic in 1 hour. Our topic today is alternative legal framework. That is the United Nations guidelines. There are two topics covered here. There are two topics, mainly Tokyo rules and Nelson Mandela rule. That is a nickname given to the topic. Original name from Tokyo rules is standard minimum rule for non-custodial measures, and Nelson Mandela rules, original name is standard minimum rules for treatment of prisoners. So everybody should right now seeing in the news that conflict between Russia and Ukraine. While in the news you have heard the name of the United Nations. I'm going out of a limb and guessing everyone knows what is United Nations organization. If someone don't, I will repeat for him. The United Nations organization is an international peacekeeping organization formed by 50 founding countries after the World War II. Everybody knows that World War II is a great devastating war happened happened on the face of the earth. In the year in the 1945, World War II ended, and the voice gained popularity that there should be an organization to maintain the peace in the entire world. So UN was founded in 1945. There are 50 founding countries to the UN, but right now entire world, almost entire world, all sovereign countries of the world are part of the United Nations. Roughly the members of 193 members are there in the UN. So in the topic we have we will go by sequence. The first rule we are taking that Nelson Mandela rules, or the standard minimum rules for treatment of prisoners. First of all, in the World War II, there were a lot of POWs, normally called as prisoners of wars. It means prisoners of war means when two countries are fighting, each country takes some of the soldiers of another country as a prisoner. They keep those soldiers in a prison. They were treated in very inhuman condition. Their inhuman torture were used to demoralize the enemy soldiers. So after ended of World War II, when the UN was founded, the first guideline adopted by UN was the if any war again happens in the world, no POWs were to be taken, and if there are any POWs, should be returned after the war ended. So after World War II in 1995, there was a need. There should be like some guidelines to the member nation, that member nation should draft a law that states that how the prisoners should be treated. First of all, what is prisoner? Prisoner is any person who is kept in the custody or jail because he does not abide the law of the land. So law of the land states this, you should not do this, and the person go against that law. There something is a punishment by law. That punishment can be imprisonment, fine, or something. But in which law the punishment is imprisonment, the person is kept in the jail, judicial custody. So after foundation of UN, and everybody started taking that there should be something, that law, so some law, that how prisoners should be treated in the prison. Like most of we study the human rights. What are the human rights? Human are the basic rights given by the sovereign country to its citizens that enjoy and that cannot be touched by any law. So prisoners do have those basic legal rights that can't be taken away from them. These rights include right to food, right to water, protection from torture. Like in some prisons there are ragging or racial harassment. There are so these should be avoided. Another right is most important right to the which should be provided to prisoners is the right to an attorney. Prisoner should be able to defend himself by himself or appointment of advocate. This is the basic rights of prisoners. Due to this whole situation of World War II and POWs, United Nations formulated a committee, and the Congress of Prevention of Crime and Treatment of Offenders adopted the initial rules in 1955, that basic rights of prisoners and standard minimum rules for treatment of prisoners. So these rules, I will show you the rules and the rules are those rules are formulated in 1995. So right now we are living in 2022. That's approximately 75 years away from original formulation. So due to change in the world and correctional science and everything, there are various advancements made in the international law. So United Nations form another committee in 2011, intergovernmental committee. Intergovernmental committee was set up to upgrade the standard minimum rules for treatment of prisoners. There was a voice that these rules now need to be updated. So those rules were updated, and everybody knows that 18 July is International Nelson Mandela Day. Those who don't know Nelson Mandela is also called as Gandhi of South Africa. He is Nelson Mandela was a president of South Africa who spent 27 years of his life in the prison. So avoid his struggle in some form of way, the standard minimum rules for treatment of prisoners is a given name, the Nelson Mandela Rule, in 2011 by Intergovernmental Committee. Those rules were adopted by United Nations officially on 18 July 2015 on the International Nelson Mandela Day. So I will show you the Nelson Mandela rules in a broad PDF form. Those rules are divided into 30 heads, and there are total 122 rules. So we don't have time to understand and read and understand each and every rule. So I'll go brief over the rules, and then I'll relate those rules against the implementation of those rules in India. Oh, just a minute. I'll get the rules on. Okay. So see, these are the rules provided by United Nations. This is the latest draft that rules adopted in 2015 called as Nelson Mandela Rules. United Nations Standard Minimum Rules for Treatment of Prisoners. So first part is basic principle, like how prisoners shall be treated. Prisoners shall be treated with their inherent dignity and value as a human beings, that no prisoner shall be harassed on the caste, religion, race, anything. So if we go, the second rules states that these are the standard minimum rules, that is guidelines. On these guidelines, the country should adopt and make a law. Like there are the laws made by India, Rights of Prisoner Act, Rights to Prisoner, Transfer of Prisoner Act, the Amendment to Prisoners Act. So those acts were made on taking base. These guidelines are taken base for those acts. So second part suggests a prisoners file management. It's like how prisoners should be managed in the jail. Like in India, there are two types of custody awarded. First is a police custody and second is judicial custody. Police custody is awarded to police that this person should be remain in police custody for the purpose of investigation, and police custody is a pre-trial phase. So post-trial, if a person is convicted, suppose say 3 years of imprisonment, the person is transferred to the judicial custody or jail. Police has no role over jail. Jail is completely managed by jail authority. Rules and regulations are formatted by jail authority and the Prisoners Act 1990. So no one can claim right over that prisoner, that police harass the prisoners in jail. That is not the part of jail authority. Police have to request the jail authority to give custody. The custody can be awarded by court also. So if we go, there are these guidelines suggest the categories should be separate, like based on male section, female section. If there are some mentally challenged prisoners, they should be kept in another section. These rules also provide guidelines for the accommodation of prisoners, like how many prisoners should be in one room, or how their cells should be arranged. Personal hygiene of the prisoner, how hygiene should be maintained in prison. Clothing, bedding should be provided to prisoner. As school and college, there are uniforms to identify the students are of this college and maintain the dignity. The uniforms are provided in. So similarly, every prisoner, every jail has its own uniform. It is similar kind in the nature, but every prisoner has a uniform. Their prisoners are normally not allowed to wear their own clothing. Their clothes and are kept when the prisoners come to the jail. Their original belongings of the prisoners are kept in the separate locker. Those were to be returned to him. So another head is a food. How food is provided to the prisoner? The food should be the complete meal, not any food like one time, 2 times. There should be food should be complete in adequate nutrition should food be providing. Drinking water is safe drinking water. So these are the rules. Excessive sports, healthcare services should be provided to prisoners. Then restriction, discipline, and sanction. See, we know that every person is a not born criminal. He commits a crime to because of say, some his necessity or mental state. The purpose of punishment is not to put the person in the jail, but is to transform the person into normal human being again and adjust his behavior to the society. So there should be restrictions, discipline, sanctions. The family members of the prisoners have right to talk to the prisoners, inquire about well-being of the prisoners, and every outside authority. And see, jail authority, judiciary, and police department are three independent, separate entities. So each entity are coordinating with each other. Judiciary is a controlling authority, so we can say that judiciary gives order to police or jail authorities. So judiciary can also gives order to search prisoners and search for cells. In India, there is a writ called habeas corpus. Habeas corpus is a writ that when we High Court or Supreme Court gives a writ order under habeas corpus, which means produce the person in front of court. So if someone found that it is the person is illegally detained, or person is cannot be found, or family thinks that my family member is arrested illegally by police, family can file a writ of habeas corpus in High Court. High Court can order the police machineries to produce the person in front of court. Then, if the police person was actually arrested, High Court inquires about legality of that arrest. So, information and complaints by prisoner. Every jail authority has to keep a record regarding the complaints made by prisoners and provide those information to the government, police, or judiciary. See, as I told you earlier, the contact with the outside world. Prisoners shall be allowed to contact with outside world. That may be his friends, family members, advocate. There is another guideline that books should be provided to the prisoner. There, if books can be purchased, or libraries should be maintained in the jail. Religion. Every person in India, not in India, but in the entire world, there is freedom of religion. Any person can choose his religion or follow his religion without any pressure. So that applies to the jail also. That right applies to the prisoner also. So retention of property of prisoners. As I said, when prisoners come to the jail, all his original belongings have to be kept safe in a custody or locker somewhere. When a prisoner is out on bail, or prisoners is arrested pre-trial, and after trial prisoners is acquitted and is to be released from jail, all his original belongings should be returned intact. Notifications is like all notifications related to the family members, or any other message from family members should be given to the prisoners. It's a right of prisoners to receive notification from family members, or give some message to his family member. Investigation. There must be an internal investigation committee in every jail, as United Nations guidelines suggest that every jail has to have an internal investigation. Not every jail. They can give a group of jails in the particular area that have one internal investigation that is to separate from jail authority. So there are any complaint against the jail authority from prisoners are to be investigated by internal investigation department. Removal of prisoners. If the person is in prison for a long time and the person needs to be transferred to another prison, or to be transferred to the court for recording statement or help the investigation, person should be exposed to public as little as possible, because public can harass the prisoner, demoralize him, or even public could attack the prisoner. So there should be guidelines that how prisoners should be taken out from the jail to its destination and come back to the jail. Institutional person. These institutional person heading provide the guidelines for appointment of jail authority persons. The prison administration. How carefully the prison administration should be appointed. See, there are various grounds person lives on, the race, color, language, religion. So there should be a balance between all these things while appointing administration and assigning prisoners to that particular jail. So internal and external inspections. There should be system on the internal investigation department. There should be inspection department. Does inspect the prisoners, their quality of food provided, or the hygiene provided in the cell or toiletries, or etc. These are rules applicable to special categories. See, in India, imprisonments starts from 1 month to life imprisonment. So there are different category of imprisonment along with different category of offenses. So one person can be in for just a theft, and another person will be serial killer and in for mass murder. So there are various types of prisoners, various mindset of prisoners. So there are some special categories of prisoners. So these guidelines provide how these special prisoners should be treated and maintained in the jail. Their treatment, their classification. See, this to separate from others, those prisoners by reason of their criminal records or character are likely to be exercised bad influence. See, if the mass murderer is kept with the theft, there is very high chances that the thief can convert into murderer or hardened criminal, rather being converted back into the society as a normal citizen. There are some privileges are offered to prisoners and special category prisoners. These guidelines also suggested a work like rigorous imprisonment. You should have someone has heard the term rigorous imprisonment. Rigorous imprisonment means imprisonment along with the work that jail authority gives you work, various types of work in the administration of jail, like cooking for other prisoners, cleaning. Jail is maintained with the help of prisoners only. There is an administrative department such called as management. Management use help of prisoners and maintain the jail. So in the open jail system, there is a we will discuss the open jail system in the next topic, that is non-custodial measures, the Tokyo rules. But in open jail system, there is thing called prisoners live their life in an open prison. The prisoners cook their own food. Some prisoners clean their rooms and cells, whatever the case may be. Some prisoners provide entertainment. This is the concept of open prison. We'll discuss that in detail in the next topic. Education and recreation. As I told earlier, that no person is a born criminal. Person commits crime 90% because of its necessity or some mental condition. There are another reasons also, but these are two main reasons for crime being committed. Every person should have right to be transformed into normal citizen. Education is a great way to transform a human being. So educational facilities and recreational facility should be provided in the jail. Social relation and aftercare. So, if the person is convicted and given a jail sentence of 14 years, after 14 years, the society will be completely different. He needs to be adjusted with that society. So, in while person is in the jail, it cannot be just kept in jail for a long time. There should be a social interaction after case. There are various NGOs currently working in India that visits the jail. Jail authority selects the prisoner that are safe to interact with normal people. They interact with the inmates and conducts various activities with the prisoners to just to help them with their recreation and maintain their social relations. Prisoners with mental disabilities. See, we interact when we interact with a person with a mental disability. We do that with utmost care that he should not be affected or hurt. That same applies to the prisoners. Mental disability prisoners are kept completely different from other prisoners. That other prisoners should not harm them. They are provided with their medications or health facilities and everything. There is another category that prisoners under arrest or awaiting trial. The case or criminal case is registered is contested in three phases: pre-trial, the trial, and the post-trial. Pre-trial is when the crime is registered and police machinery is investigating the crime. While pre-trial, some suspects or accused may be arrested. They are detained for interrogations and everything. In the trial, the court has discretion that to decide whether pendency of trial person should be released on bail or kept in the detention. And post trial, if the person is acquitted, he is a free human being, or if person is convicted, he should be kept under judicial custody for the period mentioned by the court. So this category deals with person under arrest or awaiting trial, means prisoners in pre-trial matters. Today you registered a first information FIR. After FIR, police investigate the matter, arrest the suspect or accused. Police interrogate the accused, conduct their own investigation, produce the. It is a right of human being. If you are arrested by the police, you should be presented in court in 24 hours to take the remand of person. The court has discretion that remand should be given to the police or person should be kept in judicial custody. So in police custody, person is handed over to the police and police can interrogate him. In judicial custody, person is sent to jail and police have to request jail authority or the court to get the custody of person. So person waiting under waiting for the trial are treated differently because awaiting that person arrested may or may not be may or may not be convicted. So you have to keep him different away from convicted felons. So civil prisoners and the person arrested or detained without charge. There are various laws, mostly relating with terrorism, that gives authority to the police mastery to arrest a person and detain him how much long as they want without any charge. And the civil prisoners are the prisoners who are awarded a jail sentence for their civil frauds. So in case of India, if you have taken a loan from bank and you have not repaid and the section applied to has some criminal liabilities, after the judgment you are convicted and you are found to be guilty of that offense, you can be sent in the jail for 1 month, 3 months, whatever the court decide. So these prisoners are called civil prisoners. They have not done any criminal activity. They are just involved in the civil frauds. So in brief, these are Nelson Mandela rules, which gives guidelines to the nation that on this basis you should draft laws for treatment of prisoners. So if you have to relate these guidelines with prisoners, rights in India, Indian Constitution, Article 14 of Indian Constitution provides the prisoners should be treated alike human being and provided the concept of reasonable classification. Like article provides the basis for prison authorities to determine various categories of prisoners and their classification with the object of reformation. Indian Constitution guarantees around almost 6 freedoms to citizens of India, from which certain freedoms are not given to the prisoners, such as freedom of movement or freedom of residence, freedom of professions, etc. These rights cannot be given to the prisoners as he is in the jail. So freedom of movement cannot be awarded to him. Just a minute. So prison reforms started in India from the British era. Earlier in the Mughal and ancient India, punishment are those like we have heard in the history that punishment are avoided like death sentence, death by hanging, death by pushing from the cliff, or if you have read the novels regarding the Chhatrapati Shivaji Maharaj, that punishment are हत्तीच्या पायाखाली देणे, तोफेच्या तोंडी देणे. Those were the punishment earlier given in India. But when the British came to India and took over almost the India, re- they recognize that prison condition in India are very bad. Punishments given to the human are not according to human rights. So they have introduced radical changes in exiting prison system. See, sole purpose of sending criminal to prison is to transform him into a honest and law-abiding citizen. So you have to treat the prison like a human prisoner, like a human being. He has to miss out, he has to feel that what he is missing out if he is in prison or if he is lives in a normal society. If the prisoners is make understood, if we can make understood the prisoner that he misses out on these points, he must be willing to transform. So Indian Britishers first enacted the Prisoners Act 1894. That gives that legislation provide regulation in India that as per this act prisoners should be maintained. Under this act there are main provisions of this act. Accommodation and sanitary condition of are to be provided to the prisoners. Provisional provisions relating to the mental and physical state of the prisoners. Examination of prisoner by qualified medical officer. As per the guidelines provided by UN, separation of prisoners from like male, criminal, male, female, civil, criminal, another like convicted prisoners or under trial prisoners, juvenile prisoners, that is minor. Provision of for treatment of prisoners under trial, or provisions for parole, temporary release of furlough leave, parole. These are the points which were first introduced to India by Britishers in 1894. After around almost 100 years, the Prisoners Act was amended and the new Prisoners Act came into force, that Prisoners Act 1990. It provided that it is the duty of the government for removal of any prisoner detained under any order or sentence of any court, which is of unsound mind or lunatic asylum or other place where he will be given proper treatment. So by this amendment, the major amendment is like if the person is in and he is mentally unstable, he should not be kept in prison and he should be transferred to the asylum where he is given proper treatment for his mental condition. Like we are from Pune, so we know that Yeravada jail also has a Yeravada hospital. Then there was another act introduced in India after independence, the Transfer of Prisoners Act. That again, this act was also based on guidelines provided under this United Nations Standard Minimum rules for treatment of prisoners. The Transfer of Prisoners Act 1950. This states that how prisoners should be transferred, or if the crime is committed by the person in Maharashtra, prisoners flee to Rajasthan and arrested in the Rajasthan. How should he be transferred to Maharashtra police and the investigation is to be conducted? All these provisions are given in this Transfer of Prisoners Act. The another act was enacted in 1955, the Prisoners Act, but attendance in court. The prisoners needs to attend the court on requisition of prosecutor, defendant, or the judge. There are procedure in which prisoners should be statement of prisoners to be recorded. The court can order the jail authority to produce the prisoner before the court. All the provisions regarding this are provided in the Prisoners Act Attendance in Court 1955. So this is a brief uh, history and the details about Nelson's Mandela rules, the standard minimum rules for treatment of prisoners. I know the questionnaire session is kept after the completion of lecture, but I would like that if anyone has a question regarding this part of the topic, you should ask it right now, so it doesn't mix up with another topic. You can unmute yourself and ask the question, or you can message also.
Yes, now the platform is open for the question answer session. If anyone has any questions, please feel free to ask. You can even put your questions on the chat section.
Good evening, sir.
Yeah, good evening.
Myself, Rashmi Srivastava.
Yes.
Sir, thank you so much for the brief idea about this whole prisoner system in India and the implementation and what do you say?
Treatment
What are
of
the
prisoners
corrective
are.
measures we have taken to improve their conditions? But sir, I didn't get the concept of open jail. What exactly is it? And how
I will be
different
covering
it
that
is and
topic in the next
beneficial for
topic. It's the non-custodial method that aside from prisoners, how prisoners should be transformed. They see there are two kind of offenses. It's a minimum offense and a grave offense. So if you have just stole some bread from grocery store and you are arrested. See, you are not a born criminal, a hardened criminal. You should be treated differently from the another criminals or inmates. So, open prison is a concept. I will give you idea about open prison in next topic.
okay. Thank you so much, sir.
Good evening, sir. I'm Gayatri. May I ask you a question?
Yes, sure.
Sir, while you were telling about the education and recreation,
Yeah.
could you just put some more light on how the education is provided? Like, is it the degrees they can earn, or is it like they have some kind of informal education? If you can just put a light on that.
In the jail system, for everything you have to request whatever necessities in the court or to the jail authority. Regarding the educational or recreational facilities, every jail has its own facilities provided. Like some jails have the regular classes for English language, some jails have regular classes for social interaction. That there are different types of jail for different types of sentences. If the sentence is longer, you are kept in a different prisoners. If the prison jail is for the long-term prisoners, the prisoners avoided with a sentence more than 7 years, 10 years. There are different classes for them. You can, if you want to get a degree, you have to request to the court that I'm under the education. I want to complete this degree. You are provided with the books and educational facilities in the jail, and you are released on parole or furlough to give exams. So you can have a degree in jail, or if the mostly in India, 80% prisoners are illiterate. So they are in prisoners. They are provided with basic educational facilities. Like every jail has some educational facilities. Every jail has some basic library in the regional language, English language. You can request books. I see. There is a work provided in the jail. It's like you are rewarded for your work done in the jail. You are rewarded with some amount of money. Some you are making. There are some. If you have read the news, once there was a session conducted in Yeroda jail for teaching potteries to the inmates. Some female inmates learned the pottery, made the handmade products, and sold out. So those products were sold by jail authorities in normal market, and that amount earned from those products are given back to the inmates. So from that amount, inmates can purchase books or some whatever they want to educate themselves.
Thank you, sir. Thank you.
So anyone has any more questions or what? Okay, no one has a question, so I'll begin with the next topic. The next topic is Tokyo rules. Tokyo rules, the formal name is Standard Minimum Rules for Non-Custodial Measures. Now, what is non-custodial measures? We have seen earlier topic that custodial measure, custody means keeping person in jail. So, while give, I guess someone's mic is on. Prajakta, okay, so he's muted. So, if a person is kept under custody, like I've given to the example while considering the open jail, convicted felon are of two different types. Like person under jail, person under imprisonment for very minimal crime or a very grave crime. Those two persons should not be treated in the same manner. So there is their concept established called as non-custodial measures. Like someone has seen like web series or something American web series, you have heard most of the time it's community service is offered as a punishment. So community service or open jail are the various types of non-custodial. Non-custodial measures are like person has not should not be kept in jail. Other forms of punishment should be given to that person. So the person get most of the ability to reform himself if he is treated in humane manner, not in inhuman manner. Punishment should not always have to be harsh punishments. The goal of the punishment is transform the offender. So it is not proven that imprisonment is the only condition that is able to transform the offenders. So if you see in India, we face with overcrowding of prisons. Reason for overcrowding is India does not have very good non-custodial measures. So we have custodial measures, but not very well implemented. So if we see, I will get you the National Judicial Data Grid. See, if you can see this, you are seeing this series. The purple column, which states the total number of criminal cases. There are around 30 crores, 30, no, sorry. Yeah, 3 crores, 84 lakh criminal cases in India, out of which criminal cases are more than 23 crores pending and which are for more than 1 year old. So you can see the number of criminal cases pending in India. So if we are to be decided if only 10% of these pending cases are resulted into the imprisonment, which normally does not. Okay, the 1%, if you assume 1%, there are 3 lakh person which are going to jail. If you see the number of prisoners in India, there is National Crime Record Bureau who kept the record of every crime committed. Okay, I guess there is some issue with the internet or the website. Okay, see. If we go in the year 2020 and prisoners type on occupancy, capacity and occupancy rate of jails. You can see here, very first is Andhra Pradesh. Available capacity of Andhra Pradesh is 8,060. Population of inmate is 7,300. So it is around 80-84% of its occupancy ratio. But if we calculate of all the state, there are total state and union territories. Capacity of prison is 41 lakh, 4 lakh 14,000, and arrested and inmates are 4 lakh 88,000, which means there are 18% more prisoners than its original capacity. So it can be very well seen that India has problem of overcrowding. So these are non-custodial measures. Those measures are should be implemented to get the get the prisoner out of the prison and have another forms of punishment to him to recreate or adjust him to the society. Mostly non-custodial measures are offered to the first-time offenders or juveniles. We'll directly see the United Nations measures for non-custodial. Just a minute. I'll open the PDF of Tokyo rules. If you can see, these are standard minimum rules for non-custodial measures, which are known as Tokyo rules. These rules are provided by the Committee of Crime Prevention and Control of the United Nations. Those were adopted on 14 December 1990 by the resolution number given on the PDF, that 14/110. These rules provide similar to the Nelson Mandela rule. These rules are also provided as a base rules. On this base, member nations should adopt or formulate the laws in relationship in.
Sir, you are on mute.
Sorry, am I audible?
Yes, sir.
Yeah. Sorry. Sorry for the. So as I was saying, these are non-custodial measures. These rules for non-custodial measures provided by United Nations are just base rules. On this basis, member nations should formulate their own law of land and in relationship with their other laws. Like India has one criminal law, Indian Penal Code. If India has to implement non-custodial measures, it should be formulated in accordance with IPC. And India should use these Tokyo rules as base. So United Nations suggests that this should be implemented by every member at national, regional or inter-regional levels. And the suggestion of United Nations was that every member state after implementation should submit its report on non-custodial measures to the United Nations every 5 years. So these guidelines are divided into 6 parts and 23 topics. So we'll go over the brief. We'll go over these rules in brief. The fundamental aim. What is the fundamental aim of non-custodial measure? The present standard minimum rule provides set of basic principles to promote the use of non-custodial measures, as well as minimum safeguard for persons subject to alternatives to imprisonment. As I said earlier, imprisonment should not be the only form of punishment. These rules are provided for the greater community involvement of the prisoners, management of criminal justice and treatment of offenders. Scope of custodial measures provide that what are the scope, that who should be treated as offender eligible for non-custodial punishment. Offender must include all forms of offenders, suspected, accused, or sentenced. Suspected is police suspect that this person could be the criminal. Accused is person accused by complainant that he committed the crime, or sentenced, the person who is sentenced is convicted guilty by the court of law. So there should not be made any difference while avoiding non-custodial measures that he is suspected or accused or sentenced. Rule the
Excuse me, sir, you are on mute.
no, I guess someone is muting me or I am getting automatically muted. I don't know what's happening, but sorry, I will.
I request everyone to be careful with the features which we are using.
So if you see, guidelines provide that while drafting law by member state should not discriminate the offenders on the basis of grounds provided, like such as race, color, age, language, religion, or whatever is political opinion or whatever subject may be. There should be greater flexibility consistent with the nature of gravity of offense. Like as I said earlier, the custodial measures are awarded on the graveness of offense. What level of offense is committed? Those should be the ground for awarding non-custodial measures. Non-custodial measures are there to avoid unnecessary use of punishment in a such way that consistent sentencing remains possible. So another legal safeguard. So these also provide that non-custodial measures. If member state is implementing the law for non-custodial measures, there should be some legal safeguard to that law. That no, in India, most of the sentences are awarded as per the law by discretion of court. So that should remain possible in the non-custodial measures also. First word in definition and application of non-custodial measures shall be prescribed by law. So while drafting the law, which forms of non-custodial measures is being adopted by the nation are to be mentioned, and which type of offense or which type of prisoners should be awarded, which type of non-custodial measure should also be prescribed in the law. These are legal safeguards provided as a baseline. Pre-trial stage, pre-trial dispositions, like person, if police wants to detain the person for investigation or prevention of further crime from being happening, that is a pre-trial stage. Pre-trial detainees also are eligible for non-custodial measures. Avoidance of pre-trial detention. That means the pre-trial detention should be minimum. That person should not be in prison for uh, much more time than it is required by the law. See, in India there is a system. If you are in prison for say 2 years pre-trial or during the trial, and you are awarded the sentence of 3 years, you do not have to be in prison for another 3 years. Those 2 years are deducted. You will be in prison for more 1 year. If you have seen the case of Sanjay Dutt, under the Arms Act, he was awarded the prison sentence of 5 years. But during trial and pre-trial, he was already in court for 3 years. So after the judgment, he was in prison for another 2 years, and then he was released. So at the time of trial and sentencing stage, as similar, if during the trial, prisoners can be released on bail or be kept in prison according to the gravity of offense. How what is your offense and how much grave? See, and considering the rights of victim while providing the punishment, victims also have some rights that if you are providing giving a prisoners enjoy full life, that could hurt the victim sentiments. So rights of victims are should also be considered while providing non-custodial measures. See, in this section there are various types of non-custodial measures are given. See, verbal sanctions, warning, sometime court release the person just by giving sanction in the offense of fighting or something, so very minimum offense. There are conditional discharge. The person will be discharged on some conditions or fulfill or after the fulfillment of those conditions. Status penalties, economic sanction. We all have heard. We all heard the word sanction recently in Russia and Ukraine conflict. America imposed sanctions on Russia. All the European Union imposed sanction on Russia. So, what is sanction? Sanction is restricting that country uh, in some form of the way, whatever possible. So, economic sanction can be there, monetary penalties can be there, fines or day fines can be there, confiscation or expropriation orders, restoration of or compensation order. Compensation order is like offender should provide some compensation to the victim. And if the victim is satisfied with that compensation, victim can give NOC or does not have any objection for releasing of the victim. If you have heard in the United Arab Emirates, there is a provision that if the victim family or the victim pardons the criminal is free to live in the society or he is released from the jail. So pardon is one of the form similar to the compensation order. Like sometimes if in the UAE, if the victim family or the victim himself request the court that I do not have any objection to the offender should be released from the jail if he provides me some compensation. UAE has such provisions. India officially does not have such provision, but India also have a clause called discretion of the court. So if everything is within the law, it is discretion of court that court should listen to the victim and release the person. Suspended or deferred sentence. If I take that Sanjay Dutt's example again, under AMS Act, he was awarded 5 years of sentence. 3 years 3 years he was in prison in pre-trial and under trial time. So there is a chance that court awards 5 year sentence, and after the application submitted by the offender, court can defer his sentence. Like if we take the Sanjay Dutt's case, if Sanjay Dutt, I guess Sanjay Dutt have applied but court rejected. Person apply to the court that my sentence will be limited to the sentence served, or the time being I was already in prison, and after judgment I should be free. So this is suspended or deferred sentence. Probation or judicial supervision. We'll discuss the provision in detail in after some time. Community service order. We will also be discussing community service in detail. House arrest. I guess everybody knows what is house arrest. That arresting person in his own house. He is not allowed to go beyond the particular prescribed area. Similar to that from Ramayana, like a Lakshman Resha. Lakshman Resha is given by the court that the person should not be out of this area. He should be present in this area, should live in this area. Everything he should do in that particular area only. Post sentencing stage. the non-custodial measures can be provided after the completion of trial. Like if the person is in prison for in pre-trial stage and also in trial stage, in post-trial stage, post-sentencing stage, he can be awarded a non-custodial measures like furlough. If you recently that Baba of Sacha Dera Sacha Sauda was released on furlough for the family emergency, and after the 15 days of furlough, he was sent back to the jail. So these types of non-custodial measures can be awarded. Work or education release. When I answered the question on educational or recreation facilities, the prisoners are given the leave from prison like furlough or parole to write the exams. That is called as educational release. There are various forms of parole. Work parole or parole is given for the specific reason for the, like treatment, medical treatment, or family emergencies, or medical emergency, any other form of. There are various forms of parole in the India Penal Code and various acts of India. Pardon, as I said earlier in the example of UAE, pardon can be given from in UAE. Pardon, victim's family or victim can pardon the offender. In India, pardon is given to the pardon is a facility for of a prisoner in for are awarded a sentence of death imprisonment, death sentence. Prisoner given death sentence are eligible for pardon. President of India is whole and sole authority who decides of pardon. If the president has given the pardon, no court can again convict that person for the same crime. Generally, President of India reduce the sentence of person, like death sentence is reduced to the life imprisonment. There is no limitation on president that in how much time limit that pardon should be decided or not. In the case of Ajmal Kasab has applied for the pardon, and Honorable Prime President of that time, Pranab Mukherjee, rejected the pardon in around 7 to 8 days. And there are also some cases where death sentence criminals applied for pardon, and their application was not heard for almost like 7 to 8 years. So there is no limitation on the president. There is no compulsion on president. Implementation of non-custodial measures. There should be these guidelines provide how non-custodial measures should be implemented. The stage-by-stage guide for implementation, like supervision, duration of non-custodial measures, condition of non-custodial measures, and condition of offenders. Treatment process, that how should offenders should be treated. They're like casework, group therapies, residential programs, specialized treatments of various categories of offenders. Group therapy is an interesting topic. Like group therapy is mostly used in rehabilitation centers. Like person suffering with mental condition comes in a group and share stories with each other that helps them develop their personality. One person can have the mental condition of depression or something. He can share his condition with another person. Another person shares his stories with him, and due to these interactive sessions, their mental conditions improves. So this is called as group therapies. Group therapies are mostly used in asylum. Asylum is one of the non-custodial measures. These guidelines provide that treatment should be conducted by professionals. This treatment should be formalized in such way that after understanding offender background, his personality, his intelligence, the various types of sentence should be awarded to him. Discipline and breach of condition. The law should be drafted in such a format that when a person is awarded a non-custodial method, if he does not follow discipline or breach any of the condition, what is the result of that action? Like he is to be sent back to the prison, like, to the custodial measure, or another form of non-custodial measures. These are the guidelines provided for that. Next is staff. United Nations also gave you the brief understanding and brief guidelines that how the recruitment of staff should be done for implementation of non-custodial measures. These rules are in so much detail that if any nation has to adopt, they just have to check the applicability of these rules according to the law of land. Rest everything is provided by United Nations. Staff recruitment, staff training, how the next topic is volunteers from other and volunteers and other community resources. We normally very enthusiastic people always volunteers in some form of NGOs and governmental work, like so there are possibility of while implementation of non-custodial measures, public participation is very much important. This help the offender to transform into normal life, into general society. Interaction is a major form of transforming. You are very much likely to be transformed if you have a lot of interaction with various types of people. What we say, peoples and the major politically influenced people in the society. So if the I said earlier that if person finds out that he will miss these things if he is in prison or under some custody, he is very likely to be transformed. So the greater the public participation in the life of the prisoners, transformation chances of prisoners are very high. The research policy formulation, evaluation, and planning for the implementation. So these guidelines also provide that how should research regarding. See, every country has different types of criminal, different types of mindset of criminals. So types of custodial measures should be differed from country to country. We cannot just take the law of let's say USA and implement in India, where the mindset of people in India and mindset of people in America are completely different. So government has to do research at what custodial measures should be provided in India and what custodial measures are not suitable in India. So while conducting these research, government should take in consideration both public and private bodies. So policy formulation, linkage with relevant agencies and activities. This is a very much important point that if you are providing the non-custodial measures, the agency implementing non-custodial measures should be linked with justice system, social development, other NGOs working to reform the human being, convicted human being, or welfare agencies. There should be a linkage system in all these types of agencies, which will help the person to reform. International cooperation. This is the point that United Nations guidelines suggest that various types of coordination should be done, cooperation in at international levels. Like As we know, most of our laws are based on British and European laws. So we can cooperate with the other countries. Indian laws are followed. Some of the Indian laws are followed in UK and the US also. So these are the most generally the guidelines provided by the United Nations. These guidelines are the base by which the country should impose the non-custodial measures. Now let's say we link this non-custodial measure with Indian system. See, according to the Home Affairs Committee, the report was prepared by them. They say alternatives of custodial sentencing is appropriate starting point for considering how community sentences have been imposed in a way to control and reduce the number of prisoners. As we see, number of prisoners in India is growing, and the capacity of Indian jail is very much less than the number of prisoners. So we have to reduce the number of prisoners. Prisoners should be kept in the prison according to their gravity of their offense. If the gravity of offense is less, the non-custodial measures should be applied. So what are the types of non-custodial measures? There is in India we use the types like plea bargaining, probation, fine, house arrest, or some unpaid work. Now let's discuss the types of non-custodial measures one by one. As I earlier discussed, the community service. Community service in India is only implemented for juvenile offenders, not for the adult offenders. Community service is person is not kept in jail. He is released in the day-to-day life, but he has to perform some community work, work for the community, like work in the some uh, work for the children's school, work in the school, children, work in the adaptation centers or something like that. There are rules and regulations. There are various public departments involving cleaning department, maintenance department. Person can provide services in those department. So services to community under the code decides that how much time you should spend in community servicing. You should if the person is convicted and awarded the community sentence, the sentence will be like you have to work in this public department for 4 hours a day for 40 days, let's say 30 days. Or another condition should be like you have to complete 40 hours of this work in time period of 30 days. This is a community service. Now let's discuss the open jail system. What is the open jail system? Open jail is kind of like community we live in, where prisoners are kept in a confined area. They have their own shop, recreational centers, entertainment. Everything is provided by the jail authority. Under this open jail, uh, uh, tasks are give everybody has I guess some everybody knows what is big boss. I guess some audience some percent of audience also watch the big boss. What is big boss? The number of 10-15 person are kept in one house and they have to run their house by himself and complete the task. Similarly, there is jail but less fighting, with less fighting. So there is no fighting in that open jail. Open jail is somewhat similar to the big boss. Person are assigned with a particular task. Like if there are female inmates, those were assigned with cooking. Male inmates are assigned with heavy work or something. There are some skill labor which can be given some work for creating something. Those goods can be sold out to the general public. So open jail is a community amongst the prisoner which run itself. In that community they experience what is feel like to be living in the general society. Normally the person convicted with the higher sentence like 10 years of imprisonment, 14 years of imprisonment are given the chance to be part of open prison system based on their mental system and gravity of offense. So if we see, India attempted to introduce the non-custodial sentence in its laws. India, there are four theories of criminal justice system. Reformative theory is of punishment is followed in India. This theory states punishment should be decided on the gravity of offense. Indian criminal justice system is based on the principle that abhor the crime and not the criminal. So, if the gravity of offense is very serious, the person should be kept in imprisonment. If the offender is is deemed to be harm, if he is released in the society, he must be kept in the prison. There are various mentions of non-custodial measures like 156 Law Commission, which was formulated for the amendment of Indian Penal Code. Suggested that system of community sentencing is prevailing in various legal jurisdiction in India. Incarnation of inmates are longer term are account of pain, deprivation, isolation, and extremely unusual norms of living that they bear. So, as I said, they introduced the community sentencing in the Juvenile Justice Act. For this is the act under which the juvenile criminals, that is minor criminals below age of 18 years, are convicted. They are offered with the community sentencing. Community service order under Indian Penal Code Amendment Bill was provided, but that bill could not be passed due to dissolution of Lok Sabha at that time. That bill suggested that those offenders who have awarded with the punishment of less than 3 years should be after some time of imprisonment shifted to the non-custodial measures and awarded with the 40 hours to approximately 1000 hours of community service. Recently, there was a case in New Delhi. In that case, the convicted was a 23 years old student, and he committed an offense, but the court observed that imprisonment is not necessary for him. He is a first time offender. He has to have a chance to relive in the society and dissolve his sins. So court offered him community sentence. Let's say if the community sentences are awarded to the prisoners, we have seen the numbers of prisoners earlier, like 4,88,000 prisoners are there in India right now. Out of them, the almost 48% criminals are there just for very minimal crimes. If we take out at least 20% of those criminals from custodial measures and put them in the non-custodial measures, the number of criminals would be reduced approximately by 1 lakh prisoners. So this will drastically reduce the burden of prisoners on India. See, keeping offender in a prison is not just anything. It is also cost to the government. India incurs huge amount of money to maintain and keep the of convicted people in the prisoners. If we see that out of the on a number which we saw earlier, 4,88,000, the age group approximately 44% are from age group of 30 to 50 years old, whereas 43% are from 18 to 30 years. 18 to 30 years is the career building time period of the human being. So if the person is first time offender, not a hardened criminal, repetitive offender, he has to have one more chance to relive in the society. If we see on the educational basis, out of that 4,88,000, 42% are past basic education, that is up to 10th. 28% are illiterate. Some are 21% are below graduation but above 10th, and somewhat 1 to 2% are postgraduates. So there are we everybody knows that education is very great form of developing the person in full up to his full, in the full capacity of his character. So the United Nations guidelines provide that educational and recreational facilities should be provided in the prisons. Again, India also formatted a committee that called as Malimat Committee. The committee was formed in the era when Atal Bihari ji was Advani ji was Prime Minister. Around in the year, no, sorry, I was wrong. Atal Bihari ji was the Prime Minister in the year 2000. There were the report were given by Malimat Committee, which was headed by Deputy Prime Minister Lal Krishna Advani. That report gave about 150 recommendations which should be done to the Indian criminal justice system and the rights of the prisoners and the accused. These rights includes the right of silence, which right of silence briefly acted right against the self-incrimination. Like if you are in the trial, if you have pleaded not guilty in the front of court, so court goes further with the client. None of your statement should be self-incriminating, and if you provide such statement which gives self-incriminating suggestion, that should be nullified by court. Those were the main suggestions. There are rights of accused provided in the. There are some rights that. Hello. I guess someone was asking question. Okay, so I guess that was a mistake by someone. There is a right of accused. The right of accused that he should be made aware of what offenses or what section he is being charged with in his language. You cannot say that accused is arrested in Maharashtra. Official state language of Maharashtra is Marathi. So I am dictating all charges against you in Marathi. Accused has to be made under. There are some case laws against that, and some case laws are in favor. High Court case law, Bombay High Court state that advocate of accused can be debriefed in the regional language. Accused must be debriefed in national language. So the recent case law of Bombay High Court, the incident was accused was arrested from Tamil Nadu. He was produced in the court of Bombay police explains the all charges related filed against him to him in Hindi. So Hindi is a national language of India. Maharashtrian police obviously cannot explain the offences in Tamil or Kannada, whatever the language may be. So they explained the charges in the Hindi, and the defendants took the defend that arrest made was illegal because police does not inform all the charges against him in this his vernacular language. So Bombay High Court state that Hindi is the national language. Police cannot speak. Everybody cannot be speaking each and every language. So contention of the police is right that police informed in Hindi and not in the Marathi. So Bombay High Court upheld the action of police and strike out the defense taken by the accused. So at the last, I have to say that no society can be free of crime. How harsh law you imposed or whatever law you take, it is a myth that society can be crimeless. Crimes will be committed no matter how the stricter law you implement. We cannot implement each and every criminal from the society. So we have to implement reformative or corrective measures in the society by which the numbers of prisoners or criminal are reduced and numbers of prisoners transforming to the normal life is increased. So these, though both these guidelines provided by the United Nations are to be taken as a principle for that. So after that, I will be resting and I will take any other questions if any have. So anyone have any question again regarding both of the topics can ask now. We have 40 minutes late than time provided to me. Sorry for that, but you can ask questions now.
Yes, does anyone have any questions? Okay.
Um, Once again, good evening, sir. It was
Hello.
very beautifully explained by you and concluded very well. We can't make our society crime free, but we can definitely take some preventive measures or for the precaution to reduce the numbers of crimes or help
Yes,
them
right.
to lead the normal life by giving them a second chance. So
Yes.
you explained it very well. Thank you so much, sir, for giving your time.
Thank you so much, ma'am. I would like to thank the MAEES MIT St. Dnyaneshwar B.Ed College to provide me with a great opportunity to provide these thoughts on the wonderful audience. I would like to thank the conveyor, Surendra Herkar sir, and the Darshana Power madam.
Thank you, sir. Thank you for enlightening us on this topic and sharing your insights with us. Um, Now, I think there are no more questions. So I now request Professor Darshana Pawar ma'am to give the vote of thanks. Over to you, ma'am.
Okay, so good evening once again. Thanks on this occasion. I, Assistant Professor Darshana Pawar, on behalf of MIT St. Dnyaneshwar B.Ed College, Alandi, Devachi, would like to give a big thank you to Advocate Prajjwal Bhalgat for his efforts toward the subject, an alternative measure legal framework, the Tokyo rules, the Nelson Mandela rules. Sir, you explained everything in a very simple way. Yes, it was a very informative session. We are all inspired by your great work. Thank you once again, sir. I would
Thank you
like
so
to
much.
express my sincere thanks to Dr. Surendra Herkal, Principal of MIT B.Ed College and convener of this lecture series, for the encouragement and for taking initiative for conducting lecture series on one of the important and different topic, that is a combating radicalism. I'm also very grateful to coordinator Assistant Professor Sanjay Shinde, his efforts and technical support, all the teaching and non-teaching staff member for their valuable support. Last but not least, I would like to propose vote of thanks to the participant of the Department of Defense and Strategic Studies from Savitribai Phule Pune University, the Department of Dr. Babasaheb Ambedkar Studies, Savitribai Phule Pune University, additional DGs and police officers, the student teacher from MIT Dnyaneshwar B.Ed College, Alandi. Once again, thank you very much.
Thank you, ma'am, and thank you everyone for attending this session and making it a success. I request everyone to switch on the cameras for a group photo. I'll be clicking the photo now. Thank you so much, everyone. We will meet again tomorrow for our next session in this lecture series. Thank you so much.
Thank you so much, Rahul.
Thank you so much, sir.